Hi guys, welcome to Commercial Law Tutorials, the channel where you learn and educate yourself all about law. Whether you're an employer or you're an employee, we have you all covered. From contracts, law of purchase and sale, law of property, law of lease, and law of employment. Today we are looking at law of employment. This is our second lesson. In our first lesson, we looked at the definition and the difference between a servant and an independent contractor. Today, we are moving on to lesson number 2, the formation of contract of employment. In this lesson, we will look at the requirements for the contract of employment. And at the end of the lesson, we will look at the questions relating to this lesson. First of all, wherever there is an employment contract, there should be an offer and acceptance. There must be an offer from the employer, where the employer makes a clear job offer for which the employee should accept unconditionally. Then the job offer must contain all the terms of the contract or indicate where the terms of the contract may be found. Offer terms usually include position, duration, remuneration, working hours, holidays, and benefits. The employee should communicate then his acceptance of the job either orally or in writing. There is no particular form that is required. The contract can be either oral or in writing. Then there should be consideration. Consideration refers to something of value that is exchanged between employee and employer that makes the contract legally binding. The job, salary, promotions, and benefits are all considered as consideration. The employer offers a job and promises to pay the agreed wages in return for the employee's promise to also perform a particular task. Consideration in the contract ensures that both parties have something to gain from the employment contract. The employer is having the services done while the employee gains a salary from the employer. Now let us look at capacity. Contractual capacity refers to the legal ability of an individual or entity to enter into a legally binding contract. Contractual capacity in law of employment protects the vulnerable parties, minors, women, disabled persons. For instance, there is a minimum age for employment in every country. The contract itself should not be illegal. The contract to murder people or even distribute controlled substances, they are all legal contracts. If a contract is illegal, courts regard the contract as void and therefore unenforceable. There should be serious intention to contract wherever there is an agreement. Employee must be willing to work as required by employer, while the employer must be willing to pay. That is serious intention to contract. That was it, guys. Let us now look at the exam questions that are commonly asked. What is the significance of writing contracts compared to verbal agreements? Discuss the legal requirements for a valid contract and their importance in the employment relationships. Analyze the extent to which statutory rights affect the employment contract. Explain how changes to an employment contract can be made legally and what happens if employer imposes changes unilaterally. Employer includes a clause in employment contract stating that the employees can be dismissed at any time without notice. Is this clause legally valid? Explain. Guys, I've got products for you. I've got bags. Look at the bags, guys. And I also have got bathroom mats. You can visit my store, buy and promote me. I also have t-shirts. Look at the t-shirts, guys. They are really nice. Throw pillows. Bathroom curtains. Thank you guys for watching. Subscribe, like and comment. You can also share the video with your friends. See you next time.